SJC-11933, Commonwealth versus Robertson.
Ms. Billowitz, good morning.
Good morning. May it please the court, Elizabeth Billowitz for Anthony Robertson. There were two eyewitnesses who were allowed to identify Mr. Robertson in court after giving highly uncertain and unequivocal out-of-court IDs. This is
I'm sorry, you meant equivocal.
I'm sorry, yes. And this, of course, is precisely the scenario that this court condemned in Collins. The danger that a jury could disregard or minimize the earlier failure to make a positive ID and give undue weight to the highly suggestive in-court ID. The audio of the ID procedures was in evidence here, and both of the eyewitnesses to the murder
This is pre-Collins, right?
This is pre-Collins.
So that's your first big hurdle. Why don't we start there?
Collins should apply here because the error was preserved and it possibly contributed to the verdict. This is consistent with Collins, with Creighton, with other cases.
Not with the verdict, with the integrity of the verdict. That's what you're saying.
Yes, because objection was preserved here, the standard of review should be whether there was a reasonable possibility that the error might have contributed to the jury's verdict.
So even though Collins is prospective, we should apply it retroactively?
In this case, because...
I just don't know why we do that. Is that because you objected to it, and because you objected to it, you objected to the introduction of the in-court ID, to having an in-court ID, you therefore make Collins retroactive?
Both in Collins and in Creighton, even though those cases announced new rules, not just prospective new rules, but rules that explicitly apply only to trials taking place after that date. In both of those cases, this court considered whether the admission of the in-court IDs played a role there.
And concluded they did not? I can't remember.
In Collins, this court considered whether it was reversible error, but concluded there was no substantial risk of miscarriage of justice. The issue was not preserved there, and this court concluded that because of the partial ID, as well as there was compelling evidence of the defendant's guilt. In that case, there was some physical evidence, including shell casings, linking the defendant to the murder weapon.
We've got two things going on. We got two things going on at once, though, and I think we got to separate them out. First one is it preserved? And of course, you can't preserve the issue of what didn't happen, Your Honor. I'm objecting to this in-court ID because the out-of-court ID is unequivocal, and I want to preserve that error, which could have been done in anticipation somehow of Collins. That didn't happen. It was objecting to the in-court ID on a number of legitimate reasons, including perhaps common law Jones reasons, and I think also that it was the nature of the out-of-court ID was such that there shouldn't be an in-court ID that had an independent source. So that's, you got, is it preserved or isn't it preserved?
It absolutely is preserved. Obviously,
but what, I just want to say the two different things. So is it preserved, isn't it preserved? Okay, you've got your argument there. But that's sort of getting it conflated into, well, if it isn't preserved, this is such a big deal in this particular case that we're concerned with the integrity of the verdict, and that two of them are going at the same time in your argument. So I think we need to separate them out and argue each of them.
I will absolutely do my best to do that. First of all, this was preserved here. Obviously, trial counsel couldn't mention Collins by name because that case couldn't have happened, but he moved in limine presciently, perhaps in anticipation. I believe that some of this litigation may have been going on in the lower courts at this point. He moved in limine to exclude both the in-court IDs, specifically in light of the inconclusive array proceedings, and he reiterated objection at trial very specifically on that ground. So I think the issue was indeed front and center preserved. And the judge felt constrained by the state of the law at that time, but he said, I've heard it argued before. So I think this issue was indeed on the radar, even though Collins hadn't yet been decided.
Right, but I mean, neither Creighton nor, in both Creighton and Collins, we didn't say that the judge erred. But we did, as we do in every case, evaluate substantial risk and substantial likelihood. So
Actually,
why don't we, I mean, you certainly are going to be entitled to argue, it's a 33E case, that there's a substantial likelihood of miscarriage of justice arising from any prejudice or any unfair concern about the quality of the decision of the jury based on the in-court ID, but everybody gets 33E. So, but I don't know that you get any special benefit from Collins, because Collins didn't get the benefit of Collins.
well, Collins got consideration of the issue, and you're right, it was a substantial risk of miscarriage of justice standard there, but it was unpreserved there.
Collins was a killing, was a murder, wasn't it?
Yes.
A substantial likelihood of miscarriage of justice.
That's correct. I think this case is actually more analogous to Creighton, where the issue was preserved, and that actually applied the prejudicial error standard. And there, even though this court acknowledged the judge didn't abuse her discretion in allowing the in-court ID, because that was in accord with the case law in existence at the time.
Well,
And
Creighton had 2 or 3 other problems, if you remember. I happened to write it, so I remember it better than you do. But but there were other problems in Creighton, including the photograph in the prison cell, and other things which caused concern. So it was a cumulative determination that when you add up all these things, it wasn't just that.
Absolutely, and that is the argument here, that this error in conjunction with others, and I certainly do not mean to presume to to be the Creighton
you're supposed to
expert,
do
but
that.
I think that it's worth pointing out the analogs here to Creighton, because the judge was applying the law that was in effect at the time. This court expressly acknowledged that it was applying a new standard for the first time on that day, and even said, there's powerful evidence of the defendant's guilt here, which I'm not conceding in this case, but even in light of all of that, the unreliability of the in-court IDs was included in that calculus. So I would say that there absolutely is precedent here for applying a prejudicial error standard to this situation.
How about Bastaldo? I'm quoting, because the defendant's trial took place before the issuance of Collins, this court evaluates the alleged errors under the existing law at the time of the trial.
That's correct. In Bastaldo, the error, there was no contemporaneous objection, and that was preserved. I would say that's a material difference here.
You're asking for us to apply a prejudicial error standard.
I am. Both under Collins, which I would submit this court may retroactively apply under the facts of this case where the error was preserved. Alternatively, in the very recent case of Dew, this court noted an alternative to Collins, the Collins analysis for in-court IDs, applying common law principles of fairness, and pointing out that the trial judge has, for a long time, had the discretion to exclude eyewitness IDs if the probative value is substantially outweighed by the danger of unfair prejudice. And I would submit that alternatively, that's the right fit for this case. That also was preserved. Again, not specifically citing Dew because it hadn't come out yet, but the motion in limine said this is prejudicial and misleading to the jury in light of the equivocal out-of-court IDs. So applying that analysis, which is based on case law, Johnson going back to Jones, the probative value of the ID testimony is examined in light of the strength of the source independent of the suggestive circumstances. And there are specific factors, all of which point to prejudicial error in this case. The witness's opportunity to observe the offender at the time of the crime. Both the eyewitnesses said it was dark, this happened quickly. The amount of time between the crime and the ID, between the in-court ID, there was 2.5 years. Whether the witness's earlier description of the perpetrator matches the defendant,
How
the
about the
descriptions were
phone?
extremely vague.
They're on the phone with the defendant. They're on the phone with the person with that phone number, which is the famous 857-237-4076. They're calling back and forth. I see you, there's 7 phone calls on the victims, right, something like that. It's his phone. It seems to be, there's certainly from the light most favorable to the Commonwealth, there's plenty of evidence indicating it's his phone, right? So he's there, he's on the phone, or at least someone carrying his phone is there. We got a lot of evidence here, don't we?
There is some evidence here. I would not say that it is so overwhelming that these in-court IDs didn't matter. And the prosecutor hit this hard in closing argument, going over these in-court IDs again and again and emphasizing their certainty. And again, this evokes that danger.
He does 2 things, right? First, he goes through all the evidence on the IDs, that they're possible IDs or significant possibility, right? He doesn't just, he goes through what they did, right? The prosecutor, he describes factually, accurately. Then he makes this last statement, which is more problematic, that that's a positive ID. But he puts it in context, doesn't he? Or it's she, I don't remember if it's a he or she.
I actually would contend that the prosecutor repeatedly overstated the certainty. There are several places in the closing argument.
But he presents it, I mean, I read it, he presents it accurately. Now, he characterizes it at the end, but he explains they did a possibility, a significant possibility, whatever. But he describes how it worked, didn't he? He doesn't just re-characterize the facts. He explains the facts, and then he puts his label on it.
I think it's a highly problematic label, and I would say that the prosecutor is wielding a little authority here. He's saying, that's called a positive ID, ladies and gentlemen. That's an identification. He is using some authority to take the circumstances and say, this is a positive ID. This is reliable. And
Defense counsel say something, the equivalent of the opposite, that this isn't an ID, or I suspect they did, right?
I do not recall specifically in closing argument. Certainly, defense counsel cross-examined on this point, but in Creighton, this court explicitly recognized how difficult it is for a defense attorney to convince a jury that an eyewitness's confident identification might be attributable to suggestion. So nothing defense counsel could do here, whether it was in cross-examination or closing argument, is really material. And I think, Justice Kafker, you've put your finger on a sort of interplay here that's very important, both the admission of the in-court ID coupled with the way the prosecutor characterized it in closing argument. These 2 things together were, really a perfect storm of, pointing towards this problematic risk that we know about. And just briefly to get back to that due analysis, which I really do think, if this court is reluctant to retroactively apply Collins, that is an equally...
Here's the problem with due, though. The problem with due is that what you're saying is that that the probative value of the in-court ID that was equivocal, as a matter of common law from Jones, is substantially outweighed by the danger of undue prejudice. The problem with the due argument, though, is that when we're dealing with Mass Evidence Guide 403, we're looking at the judge's balance of probative value and undue prejudice, the discretion that the judge is entitled to so much deference in weighing probative value and undue prejudice that preserved error doesn't help much there, because it's a judgment call.
Well, it's a judgment call that I'm not sure, that the judge didn't seem to realize that he could make. And he
okay.
indicated he felt constrained by the law
Okay.
on this point.
Which in February of 2014 was what probably every Superior Court judge thought at the time,
Well,
that in-court IDs were admissible because they routinely were.
that's right,
we
but,
didn't. I mean, I allowed them in.
well, and I would say that
Those were the good old days.
Or the bad old days, as we later determined, but in any event, they were the old days. The world was that until Creighton and Collins, judges routinely admitted in-court IDs, and I understand all the concerns, and
Yes.
I appreciate
And-
your concerns and why, but the problem I have with the problem I have is that if we view it as a totality, if this were a pure ID case, you'd be on stronger ground. But with all the evidence with regard to the circumstantial evidence tying the telephone calls to the phone and to his phone, there is a substantial circumstantial weight to the evidence that is, which I know is why you want the prejudicial standard, because you need the prejudicial standard as opposed to the substantial likelihood standard. So, but if you don't get the prejudicial standard, speak to us about whether or not you can prevail on the substantial likelihood of a miscarriage of justice standard.
again, this was an ID case. These witnesses were the heart of the case. Yes, there was other circumstantial evidence, but most of it conflicting. One of the eyewitnesses did not hear the victim say aunt, say don't do this, aunt. The other one didn't remember or didn't disclose that he heard that name until after he had been repeatedly interviewed by the police, and in early interviews disclaimed any names being said at the time. The phone evidence is also somewhat equivocal. The nickname evidence is also conflicting. Some people say that he was called aunt, some people say he was called something else. The phone evidence, really, there was only one witness who said that this phone number was used by Mr. Robertson. Her testimony was a little bit all over the place. She appeared in the grand jury in shackles. She was a reluctant witness there. If I were a juror, I would look at that mess, and then I would look at these two eyewitnesses who came in and who the prosecutor tells me, that's a positive identification, ladies and gentlemen. If I were a juror, I would be looking to those people, and I think if you take that evidence out, if you take those identifications out, I don't think we can have confidence in this verdict.
But I think that last point that you're making, what I took from your brief is that you're saying that the overwhelming 4076 evidence, the telephone number, the CSLI, it's just the probativeness of that and the weight of that evaporates without the identifications.
That's right.
That's what I took from
Yes,
the brief.
absolutely. I mean, without that connection, there's certainly ample evidence that the 4076 number was connected to this murder. There's considerably less evidence that my client was using that. I'm certainly not saying none, but that evidence connecting him was weak enough that the eyewitness IDs here made a difference.
Okay, thank you.
Thank you.
Ms. Leary?
Good morning, may it please the court. Catherine Leary for the Commonwealth. With me today is the trial prosecutor, David Fredette. We ask the court to affirm the defendant's conviction for the first-degree murder of Aaron Warnham. So I'll start with the in-court identification issue since took up most of my sister's time. Here, the in-court identification was proper, and the judge did not abuse his discretion. As this court has held numerous times, Collins is a prospective rule, and so therefore we're looking at whether or not the in-court identification was proper under the case law at the time. And I would note that the defense counsel noted at the motion in limine stage that he didn't file a motion to suppress the identifications because the out-of-court identification procedures were not unduly suggestive. And that's the only time under the case law at the time when an in-court identification would be inadmissible or under the common law principles of fairness.
Back to Justice Lowy's earlier question, was the objection that it was unduly suggestive, or what was the objection? Or was it a prescient Collins type of objection?
Your Honor, my reading of the objection is one that this wasn't preserved under Collins, and my reading of the argument was that
Was or was not?
was not a
The microphone a little,
I'm
sorry.
sorry, was not a Collins objection. My reading of the reasoning that the defense counsel was objecting was that it was unfair and that its prejudicial value was outweighed probative value because of the nature of the out-of-court identifications. But I don't necessarily think it was quite a Collins objection. And either way, I think, as this court noted, first of all, I don't think Collins should apply in this case, but even if you apply a prospective rule retroactively, which this court should not do, here there's no substantial likelihood of miscarriage of justice, prejudicial error, or integrity of the verdict was suspect due to the overwhelming nature of the case. You had evidence that the victim said, "Aunt, don't do this before you shoot," and that aunt was his nickname from multiple witnesses. There was evidence that the victim was on the phone with the defendant with a phone number that was linked to the defendant through one witness who named the phone number, another witness who said, "Yeah, this is my phone number. This is the 4076 number. I spoke with the defendant a lot. That would make sense to me." And also the fact in the victim's phone log, he was speaking to Lil Ann from the Ave. There's CLSI evidence that puts the defendant there. There's other evidence that the defendant and the victim were together, the defendant and the co-defendant were together and left.
One thing I didn't understand about your argument, you're arguing that they have no right to privacy in the CSLI. I understand the probable cause analysis. I didn't get they have no right to privacy in their own phone number.
Well, Your Honor, this wasn't raised below. However, under Rule 13, with a motion to suppress, there needs to be an accompanying affidavit that shows an expectation of privacy. And so to do that, the defendant needs to either have his own affidavit, which he didn't include, it was just defense counsel saying it was my phone and this is my phone I use, or some other showing that it's his phone.
Any case law supporting that? Because that potentially has some wide, we're getting back to this whole Mubdi standing stuff, which I'm just trying to understand. Is there any law on this, or are you?
I would just point the court, I guess this is a distinguishing case in, I think it's Fulgrim, where even though the defendant hadn't necessarily asserted a reasonable expectation of privacy in his affidavits, he had given the phone to the police and had implicitly said, based on those facts, that it was his phone. At the end of the day, even if this court decides not to.
I understand it's easy in this case, but you're pushing an argument that may have some long, much wider ramifications. I just want to understand, is there any support for it?
I would just say that the affidavits were insufficient in this case, that there's no reasonable expectation. The defendant didn't file an affidavit saying this is my phone. Defense attorney only filed an affidavit saying it's allegedly the defendant's phone. I would suggest that allegedly is not enough to show an expectation of privacy, especially on these facts, unlike, I believe it's the Fulgrim case, where the defendant had given his phone and had implicitly shown that it's his phone based on the facts. That didn't occur here.
Is there any?
So, but you say it's his phone. Commonwealth argued it was his phone. It was a major part of the argument, that he was in possession of that phone at the time of the killing.
Correct. The defendant still needs to show an expectation of privacy, though, that it's his phone.
But isn't that sort of the reason why we gave automatic standing with regard to the issue of possession? Because we didn't want to force a defendant to say you need to admit that you possessed it, and then we will convict you for possessing it.
Well, I would say there's no automatic standing here because murder is not a possessory offense and
Right,
possession of a cell phone.
I know we've not, I understand the possessory thing, I'm just looking to the,
Correct,
if you look to the rationale behind it, it is to avoid requiring a defendant where the Commonwealth claims he is in possession to have to admit it. And here, it was an important part of your case, and arguably a very important, it was a key part of your case, that he was in possession of that phone, which was in constant communication with the victim until the victim died. And now you're saying, well, he didn't show that that was his phone, but you say it's his phone.
Correct, I understand where Your Honor's coming from. The Commonwealth's position is that the defendant should be strictly held to the requirements of Rule 13 with motion to suppress, and that wasn't done here. And that was just an alternate ground for this court to affirm the trial judge's decision to deny the motion to suppress.
I understand it's not a big deal in this case, but I agree with Justice Kafka, it's a big deal. Is there any context other than obviously Four Corners warrant analysis? We have said that the defendant doesn't have to submit a Rule 13 affidavit in order to be able to, based on personal knowledge, in order to be able to get the motion to suppress.
Off the top of my head, I don't know, Your Honor, so I'm sorry, I don't have an answer for that question.
Can I turn you to, the prosecutor, at least my reading of the, quick reading of the closing, he explains the evidence on the IDs, but then he does call it, this is a positive ID. I think he says it twice, maybe.
He says it once, and then he says that's an identification.
So what do we do with that? Is that, I don't know what that is, but.
Your Honor, I would suggest that is an entirely proper argument that was grounded in the evidence. What's different here is, and I think what's being conflated, is what's a positive, unequivocal ID as an out-of-court ID that's necessary to allow an in-court ID, and what's an out-of-court ID and what's fair argument.
But I'm confused. If Creighton and Collins, if particularly Collins says this isn't a positive ID, basically, aren't we mischaracterizing it?
I disagree with that. I don't think it's mischaracterizing it because here the evidence was that the that the witness picked out the defendant's photograph to the exclusion of all others. That's an identification. And in Watkins, which is an appeals court case, 63 Mass App Court 69.
Having known when 63 happened, that's way before Collins and Creighton, right? Back in as what we referred to as the old days.
Correct, but when I shepherdized it, it's still good law, and it's not been questioned that on that point I believe it was. I'm sorry, I don't have the footnote for you, but it was cited in a recent decision from this court within the past few years that argument about the certainty of a witness's identification is proper. It's fodder for argument. And the defense attorney, in his closing transcript, volume 8, page 33 through 36, discusses the out-of-court ID, and that possibly isn't a good ID, that word. So I think...
So it's fair response, I guess?
It's fair response, and I think the prosecutor's entitled to argue why the jury should find it's a positive ID, and that's his view of the evidence.
Going forward, I understand it's difficult. The prosecutor did this before Collins, but can we really call this a positive ID after Collins? Don't we need to clarify that this is it's the kind of ID that Collins doesn't like, basically.
I mean, perhaps positive was a little strong. However, I think the prosecutor would be entitled to argue that's an identification,
yes,
and that would be proper, and I think that still is proper. And I think this is a positive ID based on the fact that two witnesses, and this argument pertains just to Hicks, that where a witness picks one person out to the exclusion of the other, and the prosecutor says, listen to that audio recording of the identification procedure. He says it's a good possibility, it's a strong possibility. That's an identification, that's a positive identification.
So what's going on here is, the way I see that this is a positive ID is we can't graft onto that closing argument case law that didn't exist at the time.
Correct.
And the issue is, when he says that's a positive ID, if you read, he can't say that now in the closing argument in the context of the law. He's saying colloquially, that's a positive ID. He's not saying, oh, Creighton's gonna come out and Collins is gonna come out, so I better not say positive ID when I'm marshaling the facts.
Exactly, Your Honor. And he explained all the reasons why the jury should credit that ID, and frankly, not hiding behind certain things that maybe would be favored to the defendant, and he spun it his way, and that's just effective advocacy based on the case law at the time.
Can I ask you to talk a little bit about the peremptories here?
Sure.
So why don't you address their arguments on those?
Absolutely, Your Honor. First, the judge did not abuse his discretion, declined to find a pattern with juror 135. And just to set the scene for this juror, the Commonwealth had used one peremptory challenge before this, and it was for an Indian male who had just come to the United States a few years before. No source challenge was posited for that. And this was the first black male in the veneer to come before the court as a prospective juror. And the judge, in declining to find a pattern, said, first of all, I'm going to look out. I looked out at the veneer and said, I see a lot of faces of color. I'd be surprised to see if this is the only black male to come before the court. And also, in the record appendix here, there is one of those charts about the gender and ethnic or racial makeup of the prospective jurors in the veneer. And there were 11, at that time, there were 11 prospective jurors that were black, 3 of which were black males. And the case law is that a judge may, upon the first peremptory challenge of a certain group, may require a race-neutral reason, but they don't need to. And in these circumstances, on the record, the judge was entirely within his discretion.
And at the time, who's sitting on the jury at that time? I can't remember.
At the time, there are 2 black females, I believe, 2 white males, and 1 female. There's 6 jurors. I might, excuse me for a minute. I can check.
Okay, yep. Okay.
With regard to your concern about Moffett, we have to do 33E anyway. Why would we not consider the Moffett issues as part of our 33E review and at least address them?
Well, Your Honor, it's the Commonwealth's position that where our view of Moffett is that our view of Moffett is that it's allowed for when a defense attorney says there's no meritorious issues, then the defense is entitled to file his own brief. But this is kind of a joint representation, and while the Commonwealth did read the brief and address an issue, which the Commonwealth felt needed to be addressed, this court should just not allow this type of hybrid representation. It's not what Moffitt's meant.
Is it different because this is a murder 1 case, simply a 33E review? Moffett obviously applies to non-murder cases. Do we need to address it in this context where we have to do a 33E review anyway?
I think this court, where you do 33 review, would look at the whole record, including the defense Moffett claims. But I think perhaps this court should come out with a rule saying this type of hybrid representation should not be allowed.
In all cases? It sounds like you're objecting to Moffett in all cases.
Well, in the way it's done in this manner, not if the defense attorney, appellate counsel files a brief saying, these are the issues. It's a Moffett brief, and then the defendant files his own pro se brief.
Meaning that the defense counsel incorporates the Moffett issues into its own brief? But the defense counsel is saying I can't in good conscience make those arguments.
Correct. Well, I feel like here where the defense attorney had raised numerous meritorious issues, this type of hybrid representation just should not be allowed. It's not a hybrid representation in that classical sense of where a defense attorney writes, there's no merit to these issues, here's the 3 or 4 issues the defendant wants to raise.
My sense was that this practice was increasing among prisoners. Is that a fair statement?
I can't say beyond the experience that my office has. It happens fairly frequently, but it's not an overwhelming burden. I can't see the numbers that it happens at.
And when was the last time a Moffett claim won?
Yes, Your Honor.
Mr. Zanini's just going to have to keep fighting this one.
Understood. If the court has no further questions, Commonwealth's happy to rest on its brief.
Okay, thank you.
Thank you.